Let's see, Mr. O'Brien, you are the appellant in this case. Would you like to reserve 5 minutes, sir?
Yes, Your Honor. Thank you.
Okay, we're ready whenever you are.
Thank you, Your Honor. May it please the court, Cullen O'Brien on behalf of the petitioners, Thomas Amendola and Doza Investments, LLC. We're here to ask this court to grant the petition for writ of certiorari and remand this case back to the trial court with instructions that the court consolidate the underlying cases. This petition argues that the trial court departed from the essential requirements of the law and not consolidating overlapping cases involving the same common nucleus of operative facts regarding various investment opportunities dating back to 2015. There were two lawsuits filed within a short span of each other, and they both involve Mr. Launder and Mr. Amendola. The first one involves just Mr. Launder and Amendola and Doza. The second one involves Mr. Launder, Mrs. Launder, and Amendola.
And they, excuse me, Mr. O'Brien, the claims that are asserted in the two different cases are based on essentially the same transactions and the business relationships between these parties, but they're altogether different claims, aren't they?
They're styled as different counts. Yes. To answer your first,
and to get sort of the nub of it, right? Consolidation is always a discretionary decision. And here, what you're asking us to do is exercise certiorari jurisdiction, which means that there is no adequate, you have to establish jurisdiction, you have to establish that you've got the departure from the requirements of the essential requirements of law that will result in a harm that cannot be corrected on plenary appeal. And I don't see it with a discretionary decision on consolidation, where we've got two cases with related but not the same parties. You don't have straight up plaintiff and defendant, and you've got different claims seeking different relief on different theories in the two cases. So help me out with the basis of our jurisdiction, because I don't see it.
So let's just start then at the rule. So rule 1.270, that rule says when actions involving a common question of law, or this is part A, when actions involving a common question of law or fact are pending before the court, it may order a joint hearing or trial. Okay, I understood. And then we go to the Tracy case that talks about repugnant and inconsistent verdicts. So there is discretion, but that doesn't mean that—
I'm sorry, I don't see how we get to repugnant or inconsistent verdicts on the claims that are alleged in these two cases.
Okay, so I'm going to get there, Judge LaBritte. I appreciate your patience. So the easiest case to see this is if you look at Morgan versus Blanchard, and that's cited on pages 8, 9 of the petition. It's an amended petition, and then pages 6 and 7 of the reply. This is Morgan versus Blanchard, and this is the inverse proposition. So in that case, all of the claims that you're talking about were filed together. There was claims regarding a promissory note. There were claims regarding failure to comply with the Florida Securities Act, which we have here, and an alleged breach of fiduciary duty, which we have here. The Morgan appellant got the promissory note claim dismissed, and the other claims survived the motion to dismiss, and said, you know what, I know we have this case pending, but I want to take a direct appeal, an appeal of that promissory note claim. And this court said, no, we're not going to split up these claims because they all concern the same interrelated issues. Now, it's not a long opinion. I don't have access to the briefs or the complaints, but it's if this court would not allow a piecemeal appeal of a promissory note claim when you have a Florida Securities Act claim and a breach of fiduciary duty, then this court should require the trial court to consolidate those claims. I mean, it's the other side of the coin. So that's how you have there with the case law. If you want to get into the actual claims, so here's some inconsistencies. Here's some repugnancies. So if you go to the breach of fiduciary duty count in the first case, So that your reference for that, Judge LaBritte, is appendix pages 21 to 22. There is in the count itself, it says Launder, in fact, placed his trust and confidence in Amendola over the course of several years, loaned $1,500,000 to Omega. And it goes on.
That's just a fact, though, basing the breach of fiduciary duty. I mean, the suit on the note is a very simple legal procedure where it's a much more complicated, these other counts that have been alleged. So the fact that merely the note was mentioned as a fact in determining whether a fiduciary duty has been breached does not make it intertwined with the suit on the note.
Well, I would respectfully disagree, Judge Morrison, and here's where I would ask you to see this. The second case isn't, respectfully, I don't see it as very simple, because in the case itself, they're not saying, hey, pay me the note. They're saying that my client defrauded the Launders and not having any authority on behalf of Omega. And in fact, it's a non-existent entity that this note is issued on, and therefore he's personally liable. That's not like a simple note case. That involves fraud. There's statements about oral representations, and then that goes to the course of dealings. That is subsumed by the trajectory and the allegations of the first case, and that's why the note is referenced over and over and over again. And I would also take issue, Your Honor, respectfully, with the note being named in the breach of fiduciary duty count. That's in the count. It's not in the background facts. That's in the count. And the reason why that's important, and the case I would have Your Honor consider, is the Piquet case. I don't know if I pronounced that right, but it's from the third DCA, which is cited in the amended petition and the reply. And there were counterclaims, and I'm quoting from the case: Piquet's counterclaims for fraud in the inducement, fraud, and conspiracy are inextricably intertwined with Clairway's claims for breach of the agreement and conspiracy to breach the agreement, because Piquet's claims are premised on the agreement. Piquet's counterclaims for fraud in the inducement, fraud, and conspiracy allege that Clairway committed misconduct regarding the agreement. So there are statements throughout both cases about oral representations, same period of time. I know Judge LaBritte said it's not the same parties, and my colleague says it's not the same parties, but Mr. Launder's in both cases on the plaintiff, and Mr. Amendola is on both cases the defendant. So they're lined up, and there's a discussion throughout the cases of a time frame where they're interacting. These promissory notes were in the same time frame as the first case. If Your Honors look at the Exhibit A, getting down to Your Honor's question, Judge Morris and Judge LaBritte's question, if you look at the fraud count, okay, so now your appendix reference is 14, and it's paragraphs 43 to 47. There's this quote 2016 expects representation, which is a defined term. It's defined back on page 6 of the appendix, paragraph 14 of the complaint, and it refers to an Exhibit A. If Your Honors look at Exhibit A, it's page 24 of the appendix. There's Omega in the actual document. I mean, it's Omega Title Holdings, and I'm reading from the first bullet point, currently sending out under Florida law the first 30 cents of every dollar for title insurance. So this first case, I guess, to answer Your Honor's question, or to take issue with whether it's simple or not, in the first case, there is a legitimate entity called Omega that apparently my client's allegedly getting money for, and getting Mr. Launder to put money into. And the second case, there is no such thing as Omega. It's a non-existent entity, and my client is somehow defrauded Mr. Launder and his wife to put money into a non-existent entity. The claim says promissory note, but if you read the allegations, it says non-existent entity. That reads as fraud. Part of the issue, I think, with this, and the reason why Your Honors struck, I was trying to update the court with what's going on, is that even listening to the other arguments, every single one of the arguments that I heard before this one, it's a backward-looking analysis. You look at, okay, what's in the record, what happened, how do we interpret this and that? We are dealing with a prospective forward-looking analysis. So this is all speculative. And part of the problem with speculative analysis is we don't actually know what's going to happen. But part of the things I'm telling your honors, and I told, this is in the record raised to the trial court, is that there are going to be counterclaims and affirmative defenses. And, we're going to be saying that Omega, yes, we're going to be saying that Omega is an actual entity. So if we win on that issue in the first case, then the other case can't rule but say that Omega is an existent entity. Like this whole thing about Omega is inconsistent. There's compulsory counterclaim rule, which your honors just went into a very deep dive procedural analysis of statutes. This would be another one that would happen with the counterclaims, because there's compulsory counterclaims. So you waive your right if you don't bring a compulsory counterclaim at the right time. Which case do we bring these compulsory counterclaims in? Because both cases talk about the entire relationship between the parties and talk about oral representations. And it's going to cause a repugnant and inconsistent, to use the words of your honors in the Tracy case, or just a mess, in my own words, in litigating these two cases side by side that are set for trial, which I'm permitted to say because your honors asked for updates in the status of the case. Their case management orders, and they're both set for trial like a month apart, different trials. So then just going back to Judge LaBritte's initial, where I thought your honor was asking me, where's the starting point? I mean, just the rule says when actions involving a common question of law or fact. And so what I'm saying is we should respectfully tell the trial court that the trial court departed from the essential requirements of the law and not applying this rule. But what are the common questions of law or fact? I mean, we're talking about oral representations in both cases. The notes in the second case are part of the notes in the first case referred to in the background allegations. They're mentioned in the breach of fiduciary duty count. They are part of the definition of what the 2016 expense representation expense representation thing is. It's a defined term, which is the basis for the first fraud count. So we're going to have representations in different cases, and we're going to have adjudication, and it's going to be a mess. Now, but it's a speculative analysis. I mean, I can't say, we haven't gone to trial in the cases. I can't tell you exactly what's going to happen, but I can tell you that counterclaims will happen. And the best I can do is look at other cases. And the Morgan case seems to me to be really on point because it's the other side of the coin. Just think about it like this, your honors. If all these imagine all the cases were together. Let's say the Launders filed these cases together, and somebody lost the promissory note counts. Morgan and Blanchard wouldn't allow, if your honors followed that your honors decision in Morgan versus Blanchard, your honors would not allow that promissory note count to be appealed separately than the other counts. So I think Morgan versus Blanchard is the strongest indicia of what should happen. As far as projecting out, I've said a lot in the briefs about the overlap in the cases. I don't know if your honors have any more specific questions, or Judge Morris or Judge LaBritte, if I've answered how these cases are related enough. I didn't know if your honors were looking for law or facts or both. But because it's a forward-looking analysis, it's necessarily speculative of how things are going to interact.
So I think I'm not keeping the clock here, but I think you're probably getting close to your time. When you come back for rebuttal, I still need to understand how this culminates without speculation, but with the certainty that's required for us to exercise our jurisdiction now in irreparable harm. And I'm not sure that you fully address that.
Well,
But
Judge,
I'm going to leave that with you for your rebuttal unless you've got plenty of time left on the clock.
I don't know how much time I have, your honors. I don't see the clock.
Well, you've
I'm
got
sorry.
about 40 minutes left on your 15, but you can bleed into your rebuttal time if you want to. That's your choice.
So I'm done with my initial time, your honor.
You've
Judge
got 40
Morris?
seconds.
40 seconds.
Yeah.
Okay, I will come back, but let me just try to use up those 40 seconds quickly. Judge LeBrit, if Your Honor is suggesting that a ruling on consolidation cannot engender a petition for writ of certiorari, I think that has been decided in a number of cases, including the Tracy decision. So Your Honors can say that the court departed from the essential requirements of the law. So that can happen. It happens. Courts get reversed for failing to consolidate. If that's the answer, if that's the question you're asking, if you're asking for what's the harm, well, the harm, Judge, is the type of harm that you see in a case like Morgan versus Blanchard, or as I articulated, and I'll try again on my rebuttal. I know I'm eating into my time, but let me just say it real quick and I'll come back. Is the second case is saying that my client extracted money on behalf of a non-existent entity, essentially committed fraud. If we win that case, then we have to win the first case on the fraud counts, because the fraud count deals with an Omega entity, and we have to win on the breach of fiduciary duty count because that deals with a note. And I'll reserve the rest of my time for rebuttal, whatever I have left.
Yeah, you got about 4 minutes.
Thank you, Your
Okay.
Honor.
Yep. Mr. Mueller?
May it please the court, Your Honors. My name is Mark Mueller. I represent Dr. William Launder and his wife, Jacqueline Launder. I will try to be brief. The decision on consolidation rests in the sound discretion of the trial court. Judge Brody heard the arguments and had the ability in her discretion to order consolidation or not. She did not order consolidation. The only redress for that is to say that Judge Brody's denial departed from the essential requirements of law. And the case law is fairly clear that in order to do that, you have to demonstrate that the denial of consolidation could result in repugnant and inconsistent verdicts that can't be remedied on a full appeal. We don't have that in this case. We have two separate lawsuits. One lawsuit seeks damages on a promissory note written in favor of Dr. and Mrs. Launder. The defendant is Mr. Amendola. The causes of action are for breach of a promissory note, and the damages sought are $500,000 of money loan.
Is there more than one count in that complaint?
There are, because there are two promissory notes, one for 250 and another for 250.
Is there a fraud claim in that case?
No, there's not a fraud claim. The claim is that because Omega Title Group LLC is a non-existent entity, that Mr. Amendola, by signing on behalf of that non-existent entity, is personally responsible for it.
Which is essentially a mechanical grounding allegation to get past the fact that the named party as the borrower doesn't.
That's correct.
Okay.
I mean, he signed on behalf of an entity that doesn't exist there, and he obtained the money, therefore he's responsible.
That
now,
doesn't really require a showing of fraud. It just requires you to contextualize the situation with regard to the entity.
I agree, Your Honor. We don't need to show anything other than he signed on behalf of a non-existent entity. Now, to the extent that Mr. O'Brien says that that is a fraud claim, and therefore we have other fraud claims that are completely different, that somehow they must be tied together. And if we lose on one, that we must lose on all. I don't see, quite frankly, any connection between the two. The lawsuit that is on the investment claims, the only plaintiff is Dr. Launder, not his wife. The defendants are Mr. Amendola and his company, Doza.
Let's do it sort of the elementary school way. If you lose on the promissory note claim, do you necessarily lose on the investment claims?
Absolutely not. There's no connection
And if you
between the two.
lose on the investment claims, can you still win on the promissory note claim?
Absolutely, because there's no connection between the two. The only connection between the lawsuits is that our breach of fiduciary duty claim in the investment lawsuit which only deals with the investments, is that Mr. Amendola, by making a series of loans to Dr. and Mrs. Launder over time, ultimately totaling $1.5 million, and paying interest on those loans, made him believe that Mr. Amendola was somebody who could be trusted. And he placed his trust and confidence in Mr. Amendola by making the
What does that
investment.
have to do with the promissory note case?
But it does not have anything to do with the promissory note case. Dr. Launder and Mrs. Launder can lose on the promissory note case and still win on the investment case, and can lose in the investment case and still win on the promissory notes. Or they could lose both, or they could win both. There's no connection between the two. There's no repugnancy. There's no inconsistency.
Is there any duplicate damages that would result in if they win in both cases?
None, because although there's no pending lawsuit on the other promissory notes that are referenced in the investment case, there was $1 million that was invested, and there was $1.5 million that was loaned. That's $2.5 million total. The $1 million of invested money stands on its own. The $1.5 million of loaned money stands on its own. There's no claim that the loan money was partly investment.
So the proceeds of the promissory note are not the money that is at issue in the investment suit. Is that what you're saying?
Absolutely correct. There's no connection between the two. It's two separate piles of money. The claim that the Morgan case somehow is the controlling case, I'm not sure how that relates to anything. It's not a case involving consolidation. It is a case regarding appeals of non-final orders on partial complaints. So I don't know what that has to do with the facts in this case. And quite frankly, all of the allegations that are made in the briefs about how tied together these cases are all simply conclusory. They make a conclusory statement that they are inextricably linked, or that the trial court will be confronted with dispositive issues on the same overlapping facts, but there's never any explanation as to why that is the case. And the answer is because it isn't the case. There are no facts that are dispositive in one case that somehow will be dispositive in another case. The court could find that there is no fiduciary duty owed based upon this relationship that was developed on these loans. That doesn't change the fact that we still have a promissory note and a claim on the promissory note, and vice versa. So the idea that there's any sort of repugnant or inconsistent verdicts on the horizon is simply conclusory. And unless the court has any questions, I will stand on that argument.
Okay, any questions? No questions. Thank you, Mr. Mueller.
Your Honors, I mean, I disagree with my colleague about conclusory. I mean, I went into the facts. I think what we heard from my colleague and Judge LaBritte, your questions were, are there any connections? You know, is this just mechanical rounding? I mean, it seems tautologous. I mean, I'm pointing directly to paragraph 87, page 22 of the appendix, their first complaint. Launder, in fact, placed his trust and confidence in Amendola over the course of several years, loaned $1,500,000 to Omega. Judge Morris, this is not a background fact. This is an element of the breach of fiduciary duty claim. The paragraph 90 says Launder has been damaged by Amendola's breach of his fiduciary duties. Damaged. It doesn't specify what the nature of the damage is. We're talking about the notes in this claim, and now we have a second lawsuit regarding notes. It doesn't have to be styled fraud. And Your Honor, this mechanical grounding never came up in the record below. I mean, what it sounds like to me, it sounds in fraud, what they're alleging. We obviously deny it, but it sounds in fraud.
The
and
part
is-
where in the promissory note suit, he's alleging that Amendola, they're suing Amendola personally because there is no entity for that he signed for. You think that's a fraud claim?
No, I say it sounds in fraud, Judge, because they talk about oral representations. And, you know, to say that this paperwork was done on behalf of a non.
Well, how does it sound in fraud if a fraud claim hasn't been asserted or relief hasn't been sought?
Well, they didn't put the word fraud at the count, Judge. They put promissory note. But if you read what they're saying, it's saying that my client induced somebody to pay money on false pretenses to a non-existent entity. In my world, that sounds like fraud, and it sounds just like what they were saying in the first case. That's what I mean when it sounds in fraud. Going back to what the trial court did and the limitation of review here, I mean, we're looking at the trial court's analysis. I know Your Honors have read the transcript. At one point, the trial court suggested, well, I'm the same judge in both cases, so isn't this moot? That's not a workable solution. You know, we're not lifetime judges. Judges can change anyway. Cases can go from judge to judge anyway, and we can't have any sort of predisposition of a case just because another case that's similar is out there. We don't allow for some sort of advisory ruling. What I'm going to do here will probably happen in the other case. So that's what the judge said.
Mr. O'Brien, the difficulty with your analysis is, first of all, the judge has the discretion to decide to do this or not to do this. And if a judge makes that decision in a way that, you or some other litigant disagrees with, we have to be persuaded that that's a departure from the essential requirements of the law. That's a very steep hill for you to climb. I mean, even judges are entitled to be wrong on the law, and you don't survive that hurdle as long as they are applying the law that everybody kind of agrees. They can apply it incorrectly, and it's still not a departure from the essential requirements of the law. That's the hill that you have to climb. That's why it's so difficult to really kind of, I'm listening to what you're saying, and you're trying really hard to convince us that this note case has got some wrapped up into the fraud count in the other case. It just doesn't seem like it to me, and it's not enough to sort of say no reasonable judge would have done what this judge did, and what this judge did is a departure from the essential requirements of the law. That's your bigger problem. You've got a huge hurdle to climb. It would have to be almost like a smoking gun for us to climb it with you.
Well, Judge, I don't know that in consolidation cases there are smoking guns. I mean, in the Tracy case, it was a expository opinion that Your Honors wrote. It wasn't like the hearings.
But those facts aren't the same as we have here. They're different facts.
There are different facts, but it wasn't. It was an analysis of the facts. It wasn't like what we heard earlier today of a hearsay rule or a per se rule on tolling time in a statute, and that's not how consolidation works. It's a standard. Are there common questions of law and fact, and are there going to be repugnant or inconsistent verdicts? Forward-looking analysis.
I mean, to be honest with you, Mr. O'Brien, I was a trial judge. I sat in the trial courts for 12 years. I have to tell you, my instinct was to consolidate everything you could. It just meant one less trial and a big docket. So when a judge doesn't do it, it's a red flag to me. There must be some good reason why this judge didn't do this.
Well, luckily,
it's just
I have
sort
a
of
transcript.
counterintuitive.
I have a transcript, Judge, and most appeals that don't have transcripts, Your Honors can't say, well, we don't know what the judge was thinking, but we know what the judge was thinking. The judge told us. The judge said, well, I'm the same, suggested, because I'm the same judge, it's moot. We have what the judge was thinking. So there wasn't a good reason. That's what I'm trying to say. There was not a good reason. And my colleague, the only reason that my colleague gave, which is different than the briefs, was that he didn't want Jacqueline Launder to be involved in, duplicative discovery.
Well, the reality of it is it may not be the same judge who ends up trying these cases that you have now, but the same judge will try both cases because they're both in the same division. So I don't know that argument works either.
Well, but we have a reason, Judge, to hone in on what Your Honor said. there must be a good reason. There wasn't a good reason. We have a transcript. I got a court reporter, ordered the transcript, highlighted what the judge's analysis was. And the judge even, Judge Brody even said, sort of said that maybe we'll consolidate for discovery, and then went back on that. I can quote from the transcript, but the most important part of that is suggested that it was moot because it's the same judge. We have the judge's reasoning. Your Honor should look at that reasoning, and find there's a departure. Your Honors, shouldn't. I'm not making up what the judge said. I mean, I was there. Mr. Mueller was there, and we have what the judge said. The judge said what the judge said, and that's not a good enough reason not to consolidate. And especially in light of my colleague saying something about duplicative discovery, which I addressed in the brief, is not a reason.
Stuck with the judge's reason. And,
Just
so you know, Mr. O'Brien, you're way over your time at this point.
I'm sorry.
And it's partially my fault by my question. So anyway,
in my defense, it's a consolidated appeal. But yeah, you are stuck with what the judge's reasoning is. I mean, that's the whole point. Did the judge have a reason that was consistent with the essential requirements of the law? It's not for your honors. It's not summary judgment where you're de novoing this.
Yeah, we have the tipsy coachman rule that allows us to, even if the judge did it for the wrong reason and came to the right decision, we can go with it. But you are out of time, sir. And I've given you way more time. I've given you 2 more minutes than you were entitled to.
Thank you, Your Honor.
We got to be done. You guys did a great job. Interesting issue, and we appreciate your briefs and your oral arguments. They were very